The Corporate Transparency Act has just been struck down as potentially unconstitutional. A federal judge in Texas has recently declared a temporary injunction for nationwide compliance with the Corporate Transparency Act. So if you follow this channel, you know that we've talked about the BOI, beneficial owner information, and the CTA, Corporate Transparency Act. Basically, the federal government is asking companies and LLCs and owners and beneficial owners to submit their information, which is previously regulated by the states, into a federal database. Now, I've never advised my clients to voluntarily submit information to a federal list. Nothing good is going to come out of it. But this is really interesting. Now, I think the short answer is you are not required to file. The FinCEN, who is regulating this, has not said that there will be a grace period per se, but they have acknowledged the temporary injunction and acknowledged that nobody is responsible to file for prior entities or for new entities. So as of right now, everything is on hold. You do not need to submit your CTA form prior to the end of the year, and you don't have to do it for new entities that are potentially filed on January 1. Now, I think this is a really important question because it kind of goes to the higher level, which is, should we comply with these federal laws if enforcement is very low, if the penalties don't really seem likely, and there's a non-zero chance that they're just going to be overturned in terms of constitutionality? I don't know the answer to that question, but let's dig into a little bit of the court's opinion, because I think that if you understand where the government is coming from, that might influence your decision in the future whether you should spend the money and energy to jump into line to be in compliance right away. So the essential pieces of this are that the Constitution clearly delegates state registration and entity formation to the states. It is not something that is a federal registration. We don't submit LLCs to the federal government. It's purely a state regulated activity. Therefore, each state decides how much information to collect. Some states like Delaware, Wyoming, they're much more private and you can incorporate anonymously. Now, this is just from formation, and this is a separate obligation than filing your IRS, right? You still have an obligation to file tax returns, but that's up to IRS enforcement and completely separate from the actual act of registration. Now, the government has made several arguments about why they formed this, and the main one I think is money laundering. They just want to talk about money laundering and trying to prevent these shell corporations from doing bad business in Texas or doing bad business in the United States. However, like most people correctly realize, putting more laws isn't going to prevent the bad actors from laundering money. All it's going to do is put more regulation and burdens on lawful, law-abiding citizens, and it's not really going to curb the behavior that we think is bad. Instead, law enforcement really should use different tools. It's not necessarily a legislative thing where the federal government has oversight over every single blanket LLC, every incorporated entity. And in fact, in the court's opinion, which I read is a 50-page opinion, it is actually pretty good. They go into one of the entities here, Mustard Seed Livestock LLC. This is a Wyoming LLC, and it says they generally produce dairy products for its own use and occasionally sells surplus raw milk only to Wyoming customers. Their total income is about $30,000 in 2023, and it's not going to exceed $50,000. This is a perfect test case. This is a great plaintiff to bring this case because their activities do not fall within interstate commerce. They're not selling on the internet. They're not doing wire transfers. This is a purely local thing. This is an activity that should be regulated by the states. However, there's a little bit of a gimme. The court opens the door that says if aggregate activities have a substantial impact on interstate commerce, then the federal government could regulate. However, the way the CTA was drafted, there is no ambiguity. There is no option for people to opt out of filing if, for example, they are activity, their business activity, wholly falls within the state, and they don't touch interstate activity. So that's a real problem with the CTA as drafted and as passed. We'll see what happens with this new legislation. This may go to the Supreme Court, but for now, this is a great example of unconstitutional laws. And I think, again, talk to your lawyer, look at your business and what the risks of penalty are versus the cost of compliance. We were charging some clients $100 a pop, and they've got 10 or 20. So we were charging over $1,000 to be in compliance with this law that now suddenly is wasted money. If you were smart and you could have predicted the future, you wouldn't have spent any money or any time researching this law. So it becomes a risk-reward balance for your own personal business. But thanks for watching, and smash that like button. We'll see you next time.